Good morning. So it's been a minute since I have come to you live or by video on Attempted Tuesday. So I want to introduce myself again. My name is Stephanie Hunnell. I'm the owner of the Hunnell Law Group in Asbury Park, New Jersey. I really practice primarily in divorce and family law, but our practice is also geared towards residential real estate. Today, I want to talk to you a little bit about what happens if you disagree or don't like a court order. Unfortunately, just not liking a court order or disagreeing with it, which oftentimes you do, especially when you're not successful in court, is not a basis for you to overturn the court's order. But if the court did something wrong, misinterpreted the law, failed to appreciate a relevant fact, or if there is some new evidence, you can bring that to the court's attention by way of a couple of mechanisms. Either a motion for reconsideration, which in New Jersey you file with the same judge that made the first decision. You present your new evidence or explain in a legal memorandum why the court made the mistake and how they should fix it and why they should change their decision. But again, that's before the same court or the same judge, and that judge gets to make the decision of whether or not they're going to reconsider what they already did. You can also file an appeal. In New Jersey, again, you can file this appeal as a matter of right. So whether or not you're going to be successful is another situation, but you can file an appeal and you can present that to an appellate division where a three-court panel essentially or generally is going to make a decision regarding whether or not the court erred in some way. Understand that in family law, there's case law that says that the family law part gets a lot of deference. You can also file even after the time has expired. Actually, let me backtrack a little bit. So, the motion for reconsideration and the filing of the appeal are very, very time sensitive. So, it's very important for you if you think that you got a bad order, you disagree with the decision, and you think the court did something wrong. It's extremely important that you get before another attorney, whether it's your existing attorney or you're getting a second opinion or a third opinion regarding whether or not you have a valid case for either an appeal or a motion for reconsideration. Even after the time has lapsed for a motion for reconsideration or an appeal, you can file an application to vacate that order. That is a very difficult standard. You generally have about a year to do it, absent some extraordinary circumstances. And in those cases, you can file and request that the court vacate the order, either because the order is no longer necessary or the court erred in some way due to a mistake, inadvertence, or something like that. But it is a very difficult standard, generally speaking. So yeah, I mean, if you have these orders in place and you have some concerns or questions, please feel free to reach out to the firm. Again, my name is Stephanie Hunnell, the owner of the Hunnell